Good afternoon, everyone. On behalf of Fenech and Fenech Advocates, I'd like to thank you for joining us for this webinar today, organized by the TMT department of Fenech and Fenech, which is the first of a series of webinars we will be organizing in relation to everything intellectual property. We will attempt to cover most of the important factors, including the legal questions, when it comes to the creation, to the protection, and the exploitation of everything intellectual property. Today, we will be focusing on the creation of IP. We will not only look at the typical intellectual property, such as copyright and trademarks, but we will try as much as time will allow us to look also beyond the basic concepts. I'm pleased today to have with us Dr. Claudio Caruana, who is the Chief Counsel at GIG, and also Dr. Pauline Debono, who is a Senior Legal Counsel at Harvest Technology PLC. Next to me, Dr. Deo Falzon, an IP law expert who also works within the TMT law department of Fenech and Fenech. So as I said, we're trying to attack the series of webinars looking at the whole lifetime or lifespan of intellectual property from its creation up until its exploitation and beyond. And today, as I said, we will be focusing on how IP is given birth and what are the most important features, the most important considerations that one has to keep in mind through the creation life cycle of intellectual property. Needless to say, when we're talking about creative industries and we're talking about the generation of IP, we're talking about the legal recognition and the legal fruits and economic fruits that are generated through the creation of new works, be it copyrightable works, be it computer programs, being literary works, being music, anything which can fall under the umbrella of intellectual property. And when we're talking about this creation, obviously, especially in relation to companies and enterprises, this intellectual property is typically not created by the legal person, that is the company itself, but through its employees. So let's go to the first dilemma we have in front of us. And I have a question for Claudio here. Claudio, employees play a very important role in the creative aspect and the generation of intellectual property. Sometimes, however, companies fail to give the right importance on how to protect and herd their employees properly in order to ensure that anything which is being created by the company through its employees and which should be considered as an asset of the company sometimes is not given its due importance. What do you think are the basic building blocks when it comes to protecting the creation of intellectual property through a legal entity such as companies like yourself through its employees?
Good afternoon, everyone. Thank you, Antonio. Thank you, Deo, for having me. So IP is the lifeblood of any modern company, especially technology companies. In my experience, I think it's extremely important that one lays the proper groundwork ahead of, even before employing, starting to employing the developers and those that are working on creative content and creating IP. I think it's important that the company first sets a strategy, lays the groundwork, sets the policies and procedures to be able to have a plan as to how to approach the creation of IP and whether it is sensible, for example, to have IP created in-house, or whether the company will pursue a strategy of also potentially outsourcing the creation of IP. But when outsourcing, there are various options which are available. I'm sure we'll be going through them throughout this webinar. But it's important also that in such strategy and policy, one will establish the criteria to look for in the choice of consultants. Policies and procedures. What do I mean by that? I mean also having guidelines for employees, the do's and don'ts for employees in terms of, for example, let's take. I mean, obviously, I come from the gaming industry, so I'm more familiar with sort of the content creation for software. Sorry, for sports betting websites. An employee, a graphic designer, might be intrigued to use, for example, football club logos or the face of some popular sports star. I mean, this is generally protected by IP. This is copyright. So these are things that you shouldn't be doing. However, it's not so obvious because one would have always thought that using the emblem of AC Milan, Juventus is something that one can't really do because you find it on the internet. But the truth is actually very far from that. And these are sometimes the causes of unfortunate litigation. Again, I mean, you have keen users of open source models. You might get an employee that wishes to import open source code and wishes to open source everything that he's building. Again, it's important that the company sets the tone, that the company ensures that it has a policy on open source as well. Also, you might have employees coming in from other companies. And again, this is not relevant solely to the creation of computer programs, but also if you are employing lawyers, etc., anyone who is building material which is potentially subject to copyright law and protection. Again, the company needs to set its tone, needs to establish what the conditions are for the use, for example, of intellectual property that the employer might have brought with him, either from previous experiences, previous companies, etc. Because at the end of the day, there are risks for the company for using third-party owned intellectual property.
And I think if I can continue the discussion even with Pauline, I think the most important document that governs this relationship between the company and the employee is the employment contract itself. And unfortunately, many times the employment contract would not sufficiently cater for these realities when it comes to who belongs the IP, what kind of rights would the company have, and what kind of obligations would also exist on the employee himself or herself. What do you think, Pauline?
Yes, in fact, I believe that the employment agreement is not really sufficient to protect either the employee or the employer, because ultimately, in case of a breach, a properly drafted agreement would safeguard both. However, having a good clause, IP clause in the employment agreement is the very basic to have within a modern company, especially in the digital world. And we're not speaking of technology companies only. Technology is now ubiquitous. You find it everywhere, basically. So having good IP clauses in the employment agreement is basic. However, it must be beefed up with policies and procedures. As mentioned by Claudio, having a very good IP policy, setting out what should be done, what should not be done, what is acceptable for the company, is another must-have for modern companies. However, that is not enough, I believe. One very important aspect that companies should be aware of and should implement at the workplaces is training and information sessions. So, it is useless having these clauses in the agreements when very often the contracts are put into drawers and no one looks at them unless a dispute arises. Training and information sessions are critical in order for everyone to be aware of what should be done And even in order for the employer to safeguard even more his rights. So, having a dispute and simply referring to the IP clause, it might be enough for some courts, but substantiating that even further.
And if it's been properly drafted as well, Pauline, I think, because
yes,
if we take a look, we go a step backward and we look at ground zero, which is the IP clause. Sometimes you see them taking lock, stock, and barrel from potentially US implementations, which might, they would make reference to certain concepts that might not necessarily exist. And even to touch a bit on what Claudio introduced to this discussion, the fact that different types of intellectual properties exist, and obviously you need the clauses to encompass different types of intellectual properties, because in fact, even if we mention, just take an example from the presumption that exists under Maltese law, that if you have an employee creating computer programs or databases for an employer, then there is the presumption, of course, that whatever he is creating under the instruction of the employer belongs to the employer. But that presumption only exists for these specific kinds of intellectual property. So you can't just rely on the law. If you have employees or possibly independent contractors, we can touch on that as well. If they're creating other varieties of IP, then it's even more important to have clarity in the clause itself, as you are rightly mentioned.
There, if I can add as well, just having an intellectual property clause in the employment contract with, as well, potentially the assignment provisions where any work created by an employee is transferred in terms of ownership to the owners is sometimes not sufficient either, because the intellectual property clause is only ascertaining who is the owner of the intellectual property of that asset. However, when an employee terminates his employment relationship with his employer, the know-how that employee would have gained is transferred with him. You cannot simply erase the memory of that person when he moves to. And generally,
we might be able to do that in a couple of years.
No, I think there needs. I think, and I think even case law recognizes this, that you need to distinguish between what the employee has contributed as an expression, so as a fixed expression to the company, and what obviously he takes up with him as his own skill, which obviously he develops, and that is part of the part of the arrangement.
This is sorry. Although this is why you would have confidentiality clauses, post-termination confidentiality clauses. But also in our industry as well, we also find that non-compete provisions are very common, especially with employees that would have been adequately compensated during employment. And also the concept of garden leave, where the company pays for literally 3 months for that person not to do anything after he hands in the notice of termination, so that if the individual had any knowledge of any project that the company was working on, which might be a USP, that individual at least is out of the know and not entirely known, and be sort of,
it's
fully into the details.
Claudio, that you mentioned soft IP, we call it, because soft IP, like confidentiality, obligations, and even trade secrets, which incidentally in Malta we don't really focus on, but it's been the subject of a directive which has been transposed in Malta, but due to the fact that you need quite a lot of groundwork, especially from the employer's side, to delve into trade secrets and to ensure that there are the appropriate mechanisms in place, that the employee knows he's dealing with trade secrets or confidential information. But the good thing about it is that confidential information, first and foremost, it's like as long as that element of secrecy is preserved, it can literally remain secret forever. And so it's one of the strongest, I think, forms of soft IP. And it's interesting to see how this dynamic between what the copyrighted works and trade secrets and the confidentiality obligations, how they are all brought together within the same contract, of course.
And something which was mentioned earlier on, and I think we should discuss it a bit more, is that whilst our Copyright Act is recognizing this presumption when it comes to employees, the situation is not identical when we're talking about the outside creation or the contracting of the creation of IP, such as consultants, such as external developers, etc., etc. We also had a very interesting question right now as to how this landscape changes depending on the location or the jurisdiction of where the employee is based or where the consultant is based. Certain jurisdictions have a work for hire approach, whereby irrespective of whether you are an employee or a consultant, the IP generated belongs to the person who is paying for it. In this case, would be the company. But when it comes to the creation of IP outside, I think there the importance of a proper contract, again, let's say it's based on Maltese law, is essential. And in our experience, unfortunately, we see many situations where there wouldn't, let alone be an employment agreement, or where at least the law comes to the rescue. But when we're talking about a foreign consultant or an external consultant creating IP, there isn't that protection which is available at law, which if the parties remain silent, this is what applies. I don't know what to think
actually,
about
if I can just contribute, and then Claudio and Pauline can follow up, because if we're speaking about, because obviously due to the realities of COVID and potentially even before that, now we have employees working from across the globe, a bit more than what was previously done. So, okay, the contract is obviously, it's kind of, that's where you need to start. But not only that, because you need to take into consideration possible overriding mandatory provisions in those specific jurisdictions. So it's not just enough to contractually regulate your relationship, but potentially you also need to carry out some clearance into where that specific contractor or employee would be working from. Because if he's working from a specific jurisdiction, for instance, that doesn't have that automatic recognition of the one that we mentioned of computer programs, or potentially, a jurisdiction might say, if a specific author is creating IP, then it belongs to him automatically, kind of. So there could be a presumption, which is the opposite of what Maltese law states. So,
Deo, since you brought in this international landscape as well, I think it's interesting, but also to go back to the exception from the presumption that the creator, the author, is the owner. In Malta, at least it seems that the employer, when it comes to database rights and works in copyright and computer programs, the employer is given title to those IP assets which are created. However, what's interesting is that what we have come across in other jurisdictions, and perhaps you will tell me that also in Malta, but what we've seen is that this is very specific to the tasks which are either being assigned to an employee or those roles and responsibilities as identified in the job description of the employee, actually. So there will be employees which are having side projects, and it's interesting to see whether an all-encompassing non-compete provision in a contract or an all-encompassing assignment agreement in a contract for any works that a person might do will become the ownership of the employer.
I think the key thing there is, because even the Copyright Act, in fact, mentions it. It's on the instruction of the employer. And to tie in with what Pauline said earlier, because you mentioned training, and obviously there's training, there's instruction, so that is even more important. Because to benefit from the presumption, if you haven't regulated, of course, contractually, but even so, because clarity is always important.
Again, whether it is included in the employee manual or in the contract, again, having this basic knowledge being passed on to the employees is important. And I'm sure that through your experience, even you, Pauline, you came across situations where the goodwill or the good intentions of employees basically ended up creating even bigger problems.
Yes, in fact, from my experience, when there is a specific project where we felt that specific IP was going to be created, or it had a very good basis for new IP, or a new work was going to be created, we advised to have a specific IP agreement. So besides having the project agreement regulating the implementation timeframes, deliverables, and everything, we decided to have a specific IP agreement, especially in those instances where you have parties coming from different jurisdictions, as was mentioned in the question. So in that specific instance, or in those specific instances, we decided to negotiate and discuss specifically the IP creation and the assignment of the IP rights. So my recommendation would be that in such circumstances where different jurisdictions are at the table, to have a specific agreement on IP.
And I think that is also important, again, through the complete life cycle of intellectual property, that having such a separate or standalone agreement, which is very clear to understand, as opposed just to have a specific clause in a contract that only God knows where it is, when it comes to good housekeeping, at least from an IP perspective. And this, I think, would definitely come to the fore when there is a buyout, when there is an acquisition of that company. It will also give additional peace of mind to the buyer or to the investors, whatever the case would be, to have at least clarity as to who owns what. Unfortunately, there would be many situations arising whereby there is an acquisition of a technology company, or there is an acquisition of a gaming company, and there will be a lot of question marks as to actually who is the owner of what. And in various situations, there would be a need to actually have a declaration being prepared prior to the transfer or prior to the acquisition, to put everything to rest and have absolute clarity as to who owns what. But obviously, the sooner you can address these issues through the employment agreements, through the employee manuals, through the contractor agreements, the more transparency you would have on these issues.
I think this ties in perfectly as well, Antonio, with the question that we had, which was in relation to when you have independent contractors or employees working from abroad, especially when it comes to an acquisition, because then you need to carry out all that clearance at acquisition stage, when the closing timeframes may be too tight, to stay instructing some foreign lawyer to prepare a legal memo and then to prepare the necessary formalities. So it's all the more important to ensure that if you are allowing, remote working, but if you are engaging independent contractors, especially from non-EU states, where you might not be able to rely under the certain harmonized, although IP is not the most harmonized, especially copyright. So it's even more important. I'm not sure whether Claudio, you can contribute to this specific aspect, because I know that obviously you would have some experience in acquisitions, etc. So
absolutely. I mean, when it comes to acquisitions, our view is that the legal due diligence process must involve searches, must involve the collection of all contracts, must involve also a very careful reading of the change of control provisions in certain licensing agreements that you might have with third parties, certain warranties that they are providing. Also, again, before I've touched upon open source code, it's extremely important to make sure that the licenses that are being used are ones which are permissive, ones which you are happy with. I mean, in sum, what one should be doing during that exercise is ensuring that what you are thinking that you are acquiring, you can actually get it and continue to use it as it is being used today. But also, what is your vision with this IP asset that you're actually acquiring, and can you use it in accordance with your ambitions and your plans?
But let's create this scenario whereby there are still question marks. So you've carried out your due diligence and you still have question marks as to what you are actually buying or who actually owns, or whether there will be a risk of a third party 1 year, 2 years down the line making a claim on the IP which you think or you believe it's yours. Pauline, how would that how would you cater for that specific risk?
Well, obviously, you need to first assess what contracts are in place. Now, if possible, you need to prepare a memorandum of understanding or letter of understanding on the basis of what has been found. Obviously, I'm not very familiar with acquisitions, but my thinking, having the unclarity immediately, rings the bells to the companies which are acquiring, to lower the price, because having an uncertainty on such an important thing as intellectual property, especially if the company's assets are based on intellectual property. So, having a technology company which is not really sure what the IP rights are, it does not really reflect well on the goodwill. So at least you might address that unclarity through a memorandum of understanding.
And the warranties and indemnities that basically would cover you in as a lifesaver, so to speak, just in case you'll have those questions which remain.
Yes, but there again, as mentioned by Claudio, imagine having a company which with most of its software based on open source. So as most of us know, open source does not give any warranties. So, that goes back to what Claudio mentioned at the start of having a good IP strategy, which is understood by the employees. Because, having a good strategy sitting there, but having most of your employees using open source and the GitHub as their main software base or base for its computer programs, this will not help the employer and the company at all. So yes, the company needs to have a strategy. It needs to be understood by the employees and it needs to be implemented by the employees. So having a good amount of contract management and contract monitoring and software development monitoring should be there as well. In fact, I was going to mention another document that should be key to a company, especially a technology company. Obviously, I'm coming from a technology company background. So, my experience is mostly in that. One key document that a technology company should invest in is the software development lifecycle policy and procedure. So every project should be preceded by a software development program. So if the IP strategy perhaps is not in place, then at least the employer can set its oversight through the software development lifecycle. So over there, if there's a plan to use open source, then you need to plan your exit plans. For example, if something happens, what are your exit plans for that particular project? And if something happens, open source is based on the open community support. What happens if something happens to that software lifecycle during that software lifecycle?
And I think, Pauline, as well, we need to keep in mind that obviously this webinar is speaking mostly about the creation of IP, but just because we're mentioning acquisition is one form of creating an IP, because if you're an acquiring, and it's kind of a circle, if you will, because if a company is exploiting the IP, it's commercializing it, potentially it's interested in selling it on. And from the other side, obviously, then that's the entry point of that IP. So it's the creation of the IP has already been done, but it needs to go through a process, obviously, of due diligence, etc. And to go through that process and pass it, if you will, the importance of the synergies which you're mentioning between the legal team of the company that created that IP, so and which wants to pass it on. The synergies between the legal team who are implementing best practices and the actual developers themselves, because and as you're mentioning, the software life cycle, the open source policies, and all these related documents. And how you keep tabs on, because it's one thing like having drafted the document and then not communicating it or not implementing it in the employee handbook or with the appropriate personnel. If for instance the employee has some query, and I know Claudio, perhaps you can contribute something on this as well, because I know.
No, for sure. I mean, the way we look at it, I mean, obviously, from where I sit, I'm in-house legal counsel. So the way I see it is perhaps a little slightly different to perhaps how you see it, in the sense that I don't think that a lawyer should only be an advisor. I think a lawyer should be very much engaged, very much part of the product development life cycle, one of the main stakeholders, because things will get devised in a way which is a smart way, will take into account certain legal considerations, certain risks. Lawyers might know of certain contracts where you might have some kind of exclusivity arrangements with someone else, certain restrictions as to why you can or can't do this. So I think it's extremely important that lawyers are engaged as early as possible in the process, but also follow through with that process to then be an active contributor and advisor as part of that process. I mean, a recent experience that we have had ourselves was with open source, whereby we've run quite a detailed exercise into establishing what open source is actually being used by the company. So we as a legal team got involved also through the scanning of the software, identifying the code that has been used, and then identifying the licenses that has actually been used. And this is what I meant before, permissive versus restrictive. There's the permissive licenses, like the MIT licenses, the Apache licenses, which are associated with open source code, which are fine to be used because they allow you to use them quite freely and to exploit them commercially, etc. However, then you've got those that are called the strong copyleft licenses, which is the GPLs and the AGPLs, which, although are still free, they can actually end up being quite an expensive endeavor for the company, because the surrounding code where that specific OSS is embedded in will have to also follow suit and also become subject to the GPL licenses. Now imagine that we are a company is trying to sell its computer program, thinking, or on its books, it's recorded as being worth several millions. You come to sell it, a diligent buyer carries out thorough due diligence, finds out that actually, since you've embedded OSS open source code, which is subject to GPL or AGPL, then everything around it should actually be also GPL. Practically meaning that you've got no value in this software because this is all open source.
And again, I think this also ties once more to education. Potentially, many of our employees, our developers, might be technical geeks, might be technical wizards, but they follow the adage that everything on the internet is free. So they go into GitHub, they just find the right piece of code that they need to plug in here, there, or everywhere, and expect that there is no repercussion or no risk by taking that approach. Now, we all know all the positive things, all the advantages of taking an OSS kind of approach, but sometimes we completely disregard or don't even know that risks exist as you explained, Claudio. So again, I think we can discuss the law as much as we want, but a proper discussion when it comes to IP, as Pauline mentioned, is the strategy, the overall strategy of the company that has to involve the lawyers, again, at an early stage, but keep a lookout on how the IP is being created, but how much the actual people on the ground, the employees, know of what they should and shouldn't do. Probably the majority of the individuals would never seen a contract or an underlying contract about a specific software. They are not involved in that process. They would be involved, in the development side of things, but to keep them abreast, at least with these very basic considerations which you are raising, it's of paramount importance.
And I think, Pauline, because before you were mentioning synergies and, you know, and how like you have a specific strategy or lifespan, how easy do you find it, you know, to actually speak the language of the software developer is actually carrying out this work, especially when you take into consideration the OSS risks, because, you know, obviously OSS, you know, it's one thing developing software to use in-house, where potentially OSS is not much of an issue because you're just keeping that software in-house, you're not further commercializing it. But if you want to create something to, you know, move it on and further exploit it. And so it's interesting to see how the discussion progresses on your end.
Well, where shall I start? I've been working with technical people for 15 years. And my joke is that they see the world in ones and zeros. They see everything in ones and zeros. So open source, as we were saying, for them, it's open, it's free. So it's there to use, full stop. No more questions asked. And, you know, when you go and try to get them to understand what a license is, what liability is, what warranties are, what law and jurisdiction are, you know, at times it gets a bit difficult. Because in my opinion, no wonder they are sciences and we are arts. They fail to see the gray areas, and we thrive on gray areas because they are subject to interpretation, and that is where our role is. However, to say the truth, things have developed over 15 years. I think, especially if you had a few issues down the line, they start understanding, as Claudio was saying, that software is no longer only about software. It's not only about ones and zeros anymore. There is a license, and especially if the software house or the manufacturer or the supplier monitors the use of his software or his computer program, any type of computer program really, and pushes on enforcement, then they start realizing that license agreements are there for a reason. And then obviously, especially I have a government background, but I think the financial aspect is common to everyone, especially after the 2010 date financial crisis. Companies started balancing out, listen, when we are buying software, okay, there are the benefits of implementing the software and implementing the project. However, we need to check the financial aspect as well and the business aspect. So yes, after 15 years at least, we managed to understand that intellectual property, whether in the form of software, whether in the form of copyright of social media, whether in relation to the copyright of an article, it's not only that specific business arm or technical arm that needs to be involved. There's the financial team that needs to be involved from the start to check the capital against the operational costs. And there is the legal team that needs to be involved in order to understand the legal issues and the legal repercussions.
And I think on this point, Pauline, you're mentioning a very interesting aspect, and you use the word monitoring. And to take the discussion beyond, you know, the traditional intellectual property computer programs as we know them, I think branding also plays a very important part in the IP strategy. The fact that, again, software lives in a shell, that shell would be the graphic user interface or the characters of the game, or the icons of the slot machine that we want to push, etc., etc. Something which gaming companies, especially, but not only, you know, are introducing to the market, you know, on a regular basis. Claudio, where does that process start?
Well, I mean, you need to spend money to make money. You need to carry out searches. You need to make sure that whatever you're about to create can be protected, that will not face third-party infringements, because at the end of the day, they're expensive. But also, if you create something to only realize that a few months down the line or a few years down the line, you're being challenged, then you would have spent a ton of money into building a brand which does not derive any value, and ultimately you have to give it up. So ultimately, if we're talking about branding and trademarks, for example, definitely trademark searches is the place to start. I mean, the internet perhaps is your first port of call, but obviously then there are those specific registers. I mean, the UIPO, WIPO, you know, the Commerce Department in Malta, in order to carry out some of these searches. Then if you identify that there is, I mean, obviously there are a lot of businesses around, so sometimes it's very difficult to come up with a name that is absolutely and entirely unique. So there might be another name which exists, maybe in the same class that you're trying to register in, or not. But in any case, you shouldn't start a business before you do your homework, in my opinion. At least that is my advice. And
I
how
think
do you go about it?
as well, because I wanted to just go a bit earlier before we proceed on this point, because obviously you're mentioning the creation of a brand. Now, you know, brands are not exclusive to gaming companies. Even entities like Harvest, you know, sell on companies. Sometimes they will be tied to a specific brand. But it's how important is it, you know, to have the strategy in place, especially from a jurisdictional perspective, because we all know, you know, IP is not it is international in a way, but just because you have rights in a specific jurisdiction doesn't mean you hold them worldwide. Sometimes you may need to rely on coexistence agreements, for instance. Yeah. And another specific point, because before we touched upon the presumption about computer programs. Well, if you engage an independent contractor to create a specific, you know, brand portfolio, sometimes, you know, more often than not, you would rely on specialized marketing agencies, for instance, to assist you rather than an in-house team. How important is it to regulate that specific creation of IP contractual relationship? Because there you cannot rely on the presumption that it's the employers, for instance. So you know, even before speaking about trademarks, we need to speak about the copyright in that argument.
I've actually come across a case where a freelance artist was engaged by a company to paint a mural at their offices. And what the company had done, they liked it so much that they basically decided to print out, I'm not sure if it was, what do you call them, prints of it or T-shirts or what have you, but they decided to print something out and distribute it, let's say amongst their employees and their clients, etc. What happened was, in that case, the artist claimed copyright and also claimed that it was only paid for the mural. It was a very specific assignment. So also, to add kind of insult to injury, the license that you are also being given is also very specific to the engagements that you've engaged the contractor for in the first place. So in those instances, definitely, I mean, the contract that needs to be very, very carefully drafted, ensuring also, but this takes me back to the strategy, because there's a reason why there's a distinction in the presumption and the exceptions between a consultant and an employee. And I understand why a consultant is treated differently at law, because they are using their own tools, they have their own specializations and expertise. They're leveraging on previous experience that they might have had. So also there might be some discounts, if you may, that you're getting because they have done this for so many clients before, that there is an element of pre-existing work that you're being charged a nominal fee for. So again, that takes you back to the strategy. Is your strategy that everything needs to be proprietary, or are you fine with you having a license? But if you get a license, to what extent? What do you require to be granted to you, and what should you do? Is it everything under the sun? If it's everything under the sun, you need to have a very broad clause in that contract.
And especially because this will touch on even the indemnity aspect, because if you're relying on these independent contractors, as Claudia said, will rely on previous work. Then there is an added risk that they may rely on some other previous inspiration which has been done for some other client, and which inadvertently or not inadvertently, sometimes it may be incorporated in your work, and then you'll find a problem when it comes to the actual clearance of that brand when you want to further protect it as a trademark. So there, the indemnity clause then perhaps is even more important.
And to say the truth, I'm coming across a number of questions by insurance companies in relation to IPR indemnity. So especially when it comes to professional liability and professional indemnity insurances, they specifically ask whether in your contractual provisions you protect your IP even through IPR indemnity. So insurances will definitely take that aspect when assessing the amount of premium to pay. So it is very important for companies, not only obviously the main reason is to protect oneself when it comes to IPR indemnity, and to make sure that the employer or the consultant does not breach the IPR of third parties. However, companies also need to take that into account when it comes to insurance aspects.
I think let's up it a notch, because I think I'm sensing that this discussion now is going down the route of okay, you cannot see the creation of IP as something that happens in an instant or something that is happening in vacuum, but there is the reliance sometimes or many times on previous works, which brings us to the discussion of derivative works, which is, let's say, a more complex discussion than just having an employee creating something, from nothing. Now, whether it is based partly or wholly on open source software, but the fact that there is this new work which has its own independent rights or its own protection as a new work, again being derivative work. What kind of labyrinth we're talking about there, and how can we ensure that not only our risks and exposures with our customers and our partners, contractual partners, are protected, but also when it comes to the people inside, to our employees, when they start actually playing with derivative works. I don't know who would want to interject or you there.
No, I think derivative works. Well, first and foremost, I think adaptations perhaps as well, because this is where it's even more important, like to see what jurisdiction you're speaking about, because different jurisdictions describe it differently. But even from an OSS perspective, yes. But not only that, because even when creating brands, you can be relying upon previous creations, previous inspiration, and you would end up creating a derivative work of something you've already created. But even from an OSS perspective, of course, it's very easy for developers, to just, as Pauline mentioned, they have their own code bases and GitHubs to try and get a leg up in the creation of the software process. But then they would be subject potentially to diverse licenses. And before, Claudio made that specific distinction between permissive and restrictive. Well, it's even a code audit there. I would think it depends where in the strategy, where in the life expectancy of the specific software, and where you're carrying out that exercise. Because if you're doing it from before, then it's even better, because then you can tell the software developers, you issue a manual, listen, don't touch that specific license because we deem it not suitable for this specific product. But if you have to do it in the middle of the life cycle of that specific of a product, then it becomes a bit more complicated, because then you'd need to rely on audits, and potentially you'd need to foot a cost for coded. You need to recode all that. You need to code out that OSS, for instance. So that's where I think the conversation.
Well, we surely covered a lot of things, and unfortunately, we're almost running out of time. But before we do, I would like both Claudio and Pauline to give us a very quick and telegraphic wish list of what you would like to see within an organization in order to have an all-encompassing IP strategy. What would the table of contents look like? I don't know who wants to go first.
So again, I'll go back to the strategy. I think the involvement of the legal team at the very start of a project is paramount. I think getting the legal team involved in also advising on the need to have some kind of ongoing monitoring and compliance to make sure. I mean, ultimately, if you are a company creating computer programs, as an example, but at the same time, you're using a lot of third-party code, embedding it into your code or what have you, it becomes really, really difficult to monitor exactly what you've got in place. Again, I know we're talking about open source, but just another thing would be open source. You might use a specific code for a specific purpose and it might make sense, but it might not make sense to embed it in some critical and core part of your code base. So it's also important that, and training comes in again, the importance of training, that the developers need to know that just because that piece of OSS code was permitted to be used in a specific section, it doesn't necessarily mean that it's approved to be used everywhere. And this is where we come again to the importance of governance. I think governance is sometimes underestimated, especially in technology companies, but over the last 2 or 3 years, I've seen companies maturing as well in this area. Again, licenses to OSS code you might download the code and embed it with one license, but then there's a new version available, you incorporate that, and whereas previously it was subject to Apache, now it's subject to GPL. So there are all these issues as to why I think it further necessitates and underlines the importance of the legal team being critical also as an advisor to the creation of a compliance function for legal affairs as well, to stay on top of these legal affairs. So
just as a side note, with the further complexity to what Claudio is saying, because even some OSS licenses are incompatible with each other, incompatible. So if you're incorporating both of them in one specific kind of software, then the complexity is, but that's a discussion for another day, perhaps, and that's another assessment. Pauline.
Well, from my end, there's little I can add to what Claudio said. From my experience, again, what I can say is that what helps in a company is having information sessions such as yours, believe it or not, such as this one. However, what I found to be the most effective when it comes to the technical people is giving out practical examples of court cases. So they seem to have this kind of thinking that, you know, the technical world is a world on its own, and it never interacts with the legal world and with courts especially. But then when you start explaining some practical court cases that happened and what was the outcome, first of all, you know, you see their surprise that, for example, Apple and Google have a cutthroat competition in court, not only in the technology sphere. And, you know, you're starting their interest increasing. And secondly, they like, you know, criticizing the court decisions. So why they didn't, it shows that the magistrate or the judge didn't really understand the technical world and the technical background. So, you know, it's through these practical cases that you start really putting through what intellectual property law is all about. and to get them to realize that they have a very powerful tool in their hands. And sometimes, as I was saying, they have a very day and die, because after 15 years, we are partly technical as well. I'm not sure whether Claudio is of the same opinion. But you start putting over the message that the world is multidisciplinary now. It's no longer in silos, the technical, the financial, and the legal. Really need to work together in order for the company to function, and to function without having any claims, knocking at our doors.
I think you've said it all. It was a very interesting discussion. So thank you both, and thank you, Deo. I think one final point is that yes, we talked about strategies, we talked about laws, but I would want to specifically highlight what Claudio just said is the governance. So I think the IP governance, not only just the general governance of an organization, but the specific governance of intellectual property, obviously through proper strategies, through education, we have mentioned that quite a lot of time, through good contract management, and through good monitoring of what's going on in the ones and the zeros around us is essential. And definitely the lawyers, whether in-house or external, would play, I think, a key role in having that IP governance working well. So on that note, I thank you once again. I thank the people who are following this webinar. I would invite you to stay tuned for the next episode in this webinar, where we'll be focusing more on how to protect your intellectual property assets. So thank you once again for joining us, and I hope to see you again.